Okay, thank you very much. What I'd like to do is talk a bit about the historical context of blasphemy and also about issues to do with Ireland's recently established law. First thing I'd like to say is as a historian, I can tell you that blasphemy has not always been about hate crime, and the arrival of this aspect of it is really a comparatively recent phenomenon. Previously, if you go back in history, blasphemy was about things like orthodoxy, and we can look at the example of the treatment of the religious group known as the Conversos in Spain and Portugal in the early modern period. It's also been about discipline, and certainly the history of religion in Germany and the Reformation in the Netherlands indicates this. It's also been about providentialism, and the desire of ruling elites and governments to justify their own rule and protect themselves against providential judgment by taking it out on blasphemers. And certainly you have the example of numerous French kings, and indeed Venice had its own court specifically to try blasphemy, largely to ward off potential dangers to the city, which was seen as hanging over it from a number of sources. So what this led me to do historically was to think about how blasphemy has two types. First of all, such a thing as passive blasphemy, which characterized the medieval period where people expected the state to take action against blasphemers. Certainly in what we might describe as the modern period, this was replaced by what I call active blasphemy, which was states coming to place responsibility upon the individual. And I suppose the last part of my history was to indicate how, towards the very, very end of the 20th century and into the 21st century, we're going back to this conception of passive blasphemy, with the state taking and being asked to take a much wider role. And certainly this was brought home to me when I was asked to give evidence to the House of Lords Select Committee on religious offences in 2003, because it was only interested in offering a quid pro quo to the secular side of the argument. Basically it said, we will get rid of a blasphemy law in return for you allowing us to bring forward an incitement to religious hatred law. And certainly many people on the secular side of the argument considered it likely that many of the old failings of blasphemy laws could easily be recast into new incitement to religious hatred laws. But as we know, in Britain this didn't actually happen, because the incitement laws arrived before blasphemy laws were repealed. But nonetheless, it did look very much like one conception of law was handing over the baton to the next. But as we also know, events in Ireland demonstrate how poorly understood and dangerous the equation of blasphemy with incitement to hatred can actually be. So what I'm going to say now is an account of ostensibly what happened in Ireland, the issues behind it. It begins, as many of us know, with Michael Martin opposing attempts by Islamic states to make defamation of religion a crime at the United Nations level. And speaking in 2009, he says, quote, "We believe that the conception of defamation of religion is not consistent with the promotion and protection of human rights. It can be used to justify arbitrary limitations on or the denial of freedom of expression. Indeed, Ireland considers that freedom of expression is a key and inherent element in the manifestation of freedom of thought and conscience, and as such is complementary to freedom of religion or belief." But as we know, that expression from Ireland was basically run heavily into touch by the defamation law of July 2009, and particularly Section 36, which brought into being a brand new blasphemy law. Now, without going into that in too much detail, ostensibly the provisions of it are that someone can be fined €25,000 if he or she publishes or utters matter that is grossly abusive or insulting, that causes outrage, and that he or she intends to cause such outrage. This has got to offend a reasonable person who would find genuine literary, artistic, political, scientific or academic value in the matter. Now, I'm used to looking at any blasphemy law put in front of me, and normally I can trace its precedent, where has it come from? And so, you look at Ireland's blasphemy law and think, is it in any way descended from English common law? Because at the end of the day, it looks like a sort of ill-defined version of English law, as it was after the famous Coleridge dictum, which was pronounced in the case against George William Foote in 1883. This was very heavily talking about the manner as the test of the offence, what the current Irish law might consider the idea of intention. But equally, English common law protects only one law, and the Irish law was seeking to be somehow inclusive. So the next question is, does it look like the Indian Criminal Code of 1860, which is a sort of blanket law which forbids assaults upon beliefs, buildings, or religious artifacts? And indeed, I mention that because it's often brought forward as a possible alternative to blasphemy laws. But equally, the Indian Criminal Code does not contain a conception of blasphemy, and there's a clear statement of that in the Irish law. Likewise, does the Irish law look like modern incitement law? Well, no, because it carries the English common law component of intention. What it does look like in the end, when I think about it in any detail, is it looks like suggested amendments to the English law that were made in the 1930s. Whereby it was proposed that the existing blasphemy law was going to be extended, and it was only when Home Office civil servants examined the proposals in detail in the 1930s, they threw up their hands in horror and said, you simply can't do this. Such a law was only credible in the England of 1930 if it was obviously focused for all to see upon the notion of breach of the peace and public order. And that's something that seems entirely missing from Ireland's law. Besides, in the 1930s, in England, there was also an inherent problem of identifying words which appropriately drew the line of what they called then fair criticism and outrageous attack. And the analogy with Ireland's current law is with the provisions about a reasonable person finding genuine literary, artistic, or whatever merit. And simply put, this objection uttered concerns that legislation would prevent temperate criticism, which it would have no universal measure of outrageousness other than the sensibilities of the religious adherents so attacked, and the predilections of the jury. And this was something that civil servants in the Home Office in England in 1930 found utterly unacceptable. And they said this about such an idea, quote, "The ordinary law is that a man is held to intend the natural consequences of his acts. Any clause requiring a jury to look beyond the natural consequences of the acts proved in evidence and to look into the mind of the prisoner would be a considerable departure from the present law and would lead to great difficulty in its application." So given this sort of background, these are the general objections I've offered in evidence to the Irish Oireachtas. That blasphemy law is a law without real rules of evidence or proof, and the mens rea assumptions of guilt are always difficult to establish. It's an inclusive law, which Ireland's law seeks to be, but it's inadequate for protecting religions in conflict with one another or apostates from more established forms of religion. As we know, blasphemy laws are arguably against Article 14 of the European Convention, and this was recognised by the United Kingdom House of Lords Select Committee on Religious Offences in 2003. Now, particular problems with Ireland's Defamation Act and the wording of it is that there are all sorts of problems you can drive a coach and horses through. What's the definition of grossly abusive as opposed to mildly or slightly? What's the definition of outrage, which is again not clearly defined? Moreover, the need for outrage is more likely to ensue. This level of reaction is achieved from those who are offended. What does substantial number of adherents mean to be offended by blasphemous material? And this number just simply isn't defined. And what about the defences? The requirement of a reasonable person. What is a reasonable person and how is that properly defined? Likewise, what is genuine literary, artistic, political, scientific or academic value as opposed to false versions of those particular ideas. The law is also class discriminatory, since it creates provisions to protect skilled debaters but to catch the unskilled. It's impossible to define religion, and no provisions for doing this are actually in the particular provisions. And most importantly of all, perhaps, such defences can be harnessed by unsavoury and objectionable religious and political views, which would get the oxygen of publicity which would otherwise be denied to them. So what can I conclude from this, or would I like to conclude from this? That the Irish blasphemy law is substantially unwanted. There was no demand for it before its introduction. It's poorly drafted and contains innumerable legal and procedural problems within it. And Ireland's stance on the matter runs counter to what's occurring in other Western countries, and how its own actions no longer occur in isolation and convey signals to the rest of the world. And certainly this is an opinion shared by the United Nations Special Rapporteur on the subject of freedom of religion and belief, Professor Heine Bielefeld. Now, you often also hear suggestions that the Irish law has been deliberately drafted to ensure no prosecutions. But this is naive, even if it is true, because it assumes a will by government to not use such laws. It also assumes a secular worldview amongst those in power, and that this will by definition continue. And it also assumes an arrogance that they've been smart enough to cover all dangers. And certainly British Home Office officials would be bewildered if you told them that there would be prosecutions in 1977 in England, and again into the next century. So if I put my historian's hat on here, I'd like to sort of just finish by saying long-term thinking about this indicates that this whole issue starts to demonstrate what happens when those in governments think, perhaps not deeply enough, about their conflicting priorities, about freedom and enabling expression, but also their imperative of thinking about protection bequeathed to them as the result of hate crime agendas. And if we want any sort of lasting proof of how blasphemy is sort of conceived of as a hate crime, it's worth just going back over the ballot outcome at the Irish Constitutional Convention on the 3rd of November 2013. And those at the convention were asked the question, should the reference to blasphemy in the Constitution be kept as it is? 38% said yes, 61% no, and 1% were undecided. Okay, so that means they were in favour of it being removed from the Constitution. But they were asked a subsequent question, which was, should the offence of blasphemy still be an offence? And what was interesting is the question asked was, should it be replaced with new general provision including incitement to religious hatred? And that's if it were retained, and the vote for that was 53%. Should there be a legislative provision for the offence of blasphemy? A much closer vote, i.e. it's got to go from the Constitution, but we can hang on to it. 49% said yes, 50% said no. And the big telling statistic to finish with is, should it be a new detailed law including incitement to religious hatred if the law be retained? And the vote for that was 82%. And the clear implication we can draw from this is that not only do governments, but also people at large think of blasphemy in relation to the concept of religious hatred.